August 13th, 2018, Frederick, Colorado. A 33-year-old oil worker stands on his front porch and pleads with news cameras for his family to come home safely. Investigators were already tracking his phone. His wife and daughters had been buried at the oil site where he worked hours before the cameras arrived. These are 12 deadly fathers executed on death row or serving life sentences. Case 1. Chris Watts. Shanann Watts was 34 years old in the summer of 2018, and she was pregnant with her third child. She had grown up in North Carolina and had met her husband Christopher through a mutual friend years earlier. The two married and eventually relocated to Colorado for his work, settling into the house in Frederick with their two daughters, Bella and Celeste. Bella had just turned 4. Celeste was 3. Shanann worked from home as a brand promoter for a health and wellness company called Thrive, and she maintained an active social media presence that she used both to promote the products she sold and to document everyday family life. She posted frequently. The videos and photographs she shared showed a household that looked full and energetic, the girls running around, laughing, eating, getting into things the way small children do. Shanann was warm and direct on camera. She talked about her faith. She talked about being a mother. She had around 80,000 followers on Facebook at the time of her death, people who had been watching her life through her own lens for years and who would later become part of the enormous public response when she disappeared. Christopher Watts was 33. He had grown up in Cabarrus County, North Carolina, and had served a short period in the military before transitioning into work in the energy sector. He was fit, measured in his speech, and described by most people who knew him as agreeable and unremarkable, the kind of man who was easy to be around and who gave people no particular reason to look closely at him. He worked for a company called Anadarko Petroleum, operating equipment on oil and gas properties across Weld County. He made a decent salary. The family carried significant debt from the mortgage, Shanann's business, and the spending patterns that came with trying to maintain a comfortable life in a growing city. But by outward appearances, they were managing it together. What was not visible from the outside was that, by the summer of 2018, the marriage had been under strain for some time. Shanann had spent the first part of the pregnancy feeling uncertain about where things stood between them. In late June, she traveled to North Carolina with the girls to spend time with her family, partly to give the couple some space. It was during those weeks that Watts began spending time with a woman named Nicole Kessinger, who worked as a contractor for an environmental company that did business with Anadarko. They met through work and began meeting outside of it. Watts told Kessinger he was separated, that his divorce was nearly finalized. He did not tell her about the girls. He did not tell her Shanann was expecting. While Shanann was in North Carolina and then at a business conference in Arizona, Watts took Kessinger to Great Sand Dunes National Park. He researched vacation destinations. He researched jewelry. He was constructing, entirely in secret, a version of his future that required his current life to simply stop existing. Shanann returned from a work trip to Connecticut in the very early hours of August 13, 2018. She had been gone for about 5 days. A friend drove her home from the airport, dropping her off at the house on Saratoga Trail shortly after midnight. The girls were upstairs asleep. The house was dark. Exactly what passed between Shanann and her husband in the hours before dawn has only ever been partially reconstructed, most of the available account coming from Watts himself, whose explanations have shifted and changed significantly over time. What the physical evidence and his own later admissions established is that he strangled Shanann in the bedroom. He then went to his daughter's rooms and smothered Bella and Celeste. The Weld County District Attorney, Michael Rourke, would say in the sentencing hearing that Bella had fought back against her father as he pressed the breath from her body. She was 4 years old. Before he left for work that morning, Watts loaded all 3 bodies into the back of his pickup truck. He drove to a remote property in Weld County where Anadarko operated an oil and gas facility. He buried Shanann, who was 15 weeks pregnant with a son the couple had planned to name Nico, in a shallow grave near an oil storage site. He then forced the bodies of Bella and Celeste into separate crude oil storage tanks. The openings on those tanks were 8 inches in diameter. When investigators processed the scene days later, they found scratch marks on one of the children's bodies and tufts of hair caught at the rim of one of the tank openings. After that, Watts drove back to Frederick and went about his day as though nothing had happened. By early afternoon, Shanann's close friend Nicole Atkinson had grown alarmed. Shanann had not shown up for a scheduled prenatal appointment and was not answering calls or messages, which was out of character for someone who was rarely off her phone. Atkinson went to the house in person. She knocked. She called out. She called Watts, who said he didn't know where Shanann was. She eventually called the police. When officers arrived that afternoon, Watts was on the property and cooperative. He told them Shanann had left with the girls and that there had been tension in the marriage. He offered to let them look through the house. He came across as concerned and bewildered rather than evasive. That same afternoon, he walked out to the front porch and gave an interview to a local television reporter, telling the camera that he wanted his family to come home safely, that the house felt empty, that his daughters were usually everywhere around him, and now it was quiet. That footage circulated widely. People watching it, even at the time, described something about his affect that struck them as wrong, though they often had trouble articulating precisely what it was. The FBI joined the investigation quickly. Investigators pulled cell phone records, toll records, and footage from the network of security cameras on properties around the neighborhood. A neighbor's home camera had captured Watts's truck leaving the house early that morning with something in the bed that was not there when he had come home the night before. Colorado Bureau of Investigation agents traced his route toward Weld County. Cadaver dogs were deployed. The sequence of his movements became clearer within days. Investigators were focused almost entirely on Watts by the time they brought him in for a formal interview on August 15th, 2 days after the disappearance was reported. The interview lasted several hours. At some point during it, Watts told detectives that he had been responsible for Shanann's death, saying he had strangled her after telling her he wanted to separate. He claimed in that same conversation that he had then discovered his daughters had already been killed, implying that Shanann had hurt them before he hurt her. That account did not align with what the physical evidence showed. He was arrested the same day on suspicion of murder. The next morning, August 16, his daughters' bodies were retrieved from the oil tanks. Shanann was found in the nearby shallow grave. The medical examiner confirmed Shanann had been strangled and the girls had been smothered. In the weeks and months that followed, the details of the affair with Kessinger became public. Investigators found records of Watts searching online for information that, when read together, painted a picture of a man trying to work out how to exit one life and begin another. Shanann's family and friends gave extensive accounts of the marriage in the period leading up to the murders, including the financial stress the couple had been under, and Shanann's growing concern about how distant her husband had become. The picture that emerged was of a man who had decided at some point in the summer of 2018 that the solution to everything he found overwhelming about his life was to make his family disappear. Watts pleaded guilty on November 6, 2018, to 3 counts of first-degree murder, 1 count of unlawful termination of a pregnancy, and 3 counts of tampering with a deceased human body. Prosecutors agreed not to seek the death penalty at the explicit request of Shanann's family, who said they did not want another death to come from what had already happened, and who supported the guilty plea. Colorado abolished capital punishment entirely in 2020, but in November 2018 it remained on the books, and the family's wishes shaped the agreement. The sentencing hearing was held on November 19 in Greeley. Shanann's parents, Frank and Sandra Razuchek, addressed the court. Frank Razuchek told Watts he had carried their daughter out like trash. Sandra Razuchek told him she had not asked for death for him because she did not believe it was her right to make that call. Shanann's brother spoke about the disbelief that still hadn't fully settled in. Even the Watts family, represented partly by their son's attorney and partly through a written statement read in court, acknowledged the murders and asked for peace and healing. The judge, Marcelo Kopkow, described the crimes as the most inhumane and vicious he had encountered across thousands of cases in his career on the bench. When he asked Watts whether he had anything he wanted to say, Watts answered no. Judge Kopkow sentenced him to 3 consecutive life terms without the possibility of parole for the murders of Shanann, Bella, and Celeste. 2 additional life sentences for further murder counts tied to the girls ran concurrently. He also received 48 years for the unlawful termination of Shanann's pregnancy to run consecutively and 36 years for the 3 counts of tampering with a deceased body. The practical meaning of all of it was that Christopher Watts would not leave prison. He was transferred in early December 2018 to Dodge Correctional Institution, a maximum security facility in Walpin, Wisconsin, where he has remained. In February 2019, he gave an interview to investigators at the prison and revised his account of the murders a final time, admitting he had killed the girls himself and abandoning the story in which he had blamed Shanann. He has communicated through letters that have periodically become public, expressing what reads as regret, though investigators and legal analysts who have followed his case note that what he has offered has rarely been consistent or complete. Shanann and the girls were buried in North Carolina. Nico, the son who would never be born, was included on Shanann's grave. The house on Saratoga Trail was sold and absorbed back into the neighborhood. The oil site was cleaned up. Frederick went back to being a quiet town on the plains north of Denver. What happened there in the hours before dawn on August 13, 2018, stays in the record. A father who packed his family into a truck before the sun came up and drove them to a field and left them there, and then stood on his porch and asked the cameras where they had gone. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the plains of Colorado, we move next to Modesto, California, and a Christmas Eve that began like any other for a young woman 8 months into her first pregnancy. What investigators uncovered in the months that followed, and what the man closest to her was quietly doing while the whole country searched, is the story of one of the most heavily watched criminal trials in American history. Case 2, Scott Peterson. Modesto sits in the middle of California's Central Valley, about 90 miles east of San Francisco, in a part of the state that grows a large share of the country's almonds, peaches, and dairy products. It is a working agricultural city, practical and unpretentious, the kind of place where people tend to stay close to where they grew up, and where extended families often live within a few miles of each other. In 2002, it had a population of around 200,000. Its most famous native son at the time was probably the filmmaker George Lucas, who had grown up there and immortalized the town's cruising culture in his early film work. What made Modesto recognizable to a far wider audience, beginning at the end of that year, was the disappearance of a 27-year-old woman named Laci Peterson on the morning of December 24. Laci Rocker had grown up in Modesto and met Scott Peterson in 1994 while both were students at California Polytechnic State University in San Luis Obispo. She was studying ornamental horticulture, he was studying agricultural business. They began dating and stayed together, marrying in 1997. By 2002, the two were living in a house on Covina Avenue in a quiet Modesto neighborhood, and Laci was 8 months pregnant with the couple's first child, a son they had planned to name Connor. Friends and family described Laci as warm, energetic, and grounded. She had worked as a substitute teacher and had plans for how she would raise her child. She was active on the morning of December 24th, according to the account Scott later gave, watching television and tidying the kitchen before he left for the day. Scott was 30 years old. He had graduated from Cal Poly and moved into agricultural sales and later into fertilizer distribution, eventually starting his own business in the industry. He and Laci had bought the house on Covina Avenue together, and by outward measure, they appeared to be a couple preparing to start a family in the city where Laci had grown up, surrounded by her parents and siblings. Scott was known to be personable and sociable, the kind of man who made easy conversation. He had no criminal history. There was nothing in the visible surface of his life to indicate that anything was seriously wrong. On December 24, Scott said he left the house that morning to take his recently purchased aluminum boat to the Berkeley Marina, roughly 90 miles west across the valley and the Bay Hills, to go fishing. He said Laci had still been home and was planning to walk their dog Mackenzie and run some errands. When he returned to the house that evening, he said, Mackenzie was in the backyard, still wearing the leash, and Laci was nowhere. He called her mother, Sharon Rocha, and the two of them called police. A missing persons report was filed that night. Sharon Rocha would later say she already had a terrible feeling the moment Scott called. Search efforts began the following day and expanded quickly. Volunteers from the Modesto area and beyond combed parks, fields, and waterways across a wide area. Laci's image appeared on posters and signs, and eventually on national television. Her family organized and remained publicly visible, maintaining pressure on investigators and keeping her name in circulation. The case drew significant attention, partly because of the circumstances, a young pregnant woman missing on Christmas Eve, and partly because of what investigators were quietly learning about Scott Peterson in the weeks that followed. In late January 2003, about a month after Laci disappeared, a woman named Amber Frey gave a press conference alongside a Modesto police detective. She identified herself as someone who had been in a romantic relationship with Scott Peterson since they met in November 2002, roughly 6 weeks before Laci vanished. She said at the time that she had not known he was married. After learning of Laci's disappearance from news coverage, Frey had contacted the police, and investigators had worked with her to record subsequent phone calls between her and Scott. Those recordings captured Watts telling Frey, while his pregnant wife was missing and his name was appearing daily in news reports, that he was in Paris. He fabricated elaborate details about being overseas. He expressed grief about Laci while speaking to Frey, sometimes referring to her death in the past tense, during a period when she was officially only missing. The recordings, when played at trial, gave the jury an unmediated window into his capacity to maintain a false account across days and weeks while conducting an ordinary romantic relationship. Investigators by this point had formed a clear picture of someone who had been building a separate life in parallel with his marriage. Peterson had told Frey that he had lost his wife and that this would be his first Christmas alone, statements he made while Laci was still alive. He had shown Frey photographs, taken her to a gala event, and presented himself as a single man preparing for a new chapter. The affair began roughly 6 weeks before the Christmas Eve disappearance. Prosecutors would later argue the timing was significant. In the spring of 2003, 2 discoveries ended whatever uncertainty remained about Laci's fate. On April 13th, the partial remains of a male fetus, later identified through DNA as Connor, were found along the shoreline of San Francisco Bay in Richmond, California, not far from where Scott had said he went fishing on December 24. The next day, the partial remains of an adult woman were found approximately a mile away. Those remains were later confirmed to be Laci. The bodies had decomposed significantly during the months they had been in the water, and the damage made certain forensic determinations impossible. But the location aligned closely with the area Scott had said he fished that day. Scott was arrested on April 18, 2003, in a parking lot near a golf course in La Jolla, in Southern California. When he was taken into custody, officers noticed his appearance had changed since the disappearance. His hair was significantly lighter in color, and he had grown a goatee. He was carrying nearly $15,000 in cash, multiple mobile phones, camping equipment, and his brother's identification. In his car were also supplies consistent with someone preparing to travel. The image that emerged from his arrest, a man who had apparently been preparing to flee while continuing to make public appeals for information about his missing wife, became one of the defining elements of how the case was understood by the public. The trial began in June 2004 and was held in Redwood City in San Mateo County, moved from Modesto because of the intensity of local feeling about the case. It ran for months and generated an extraordinary volume of news coverage. Amber Frey testified extensively, and recordings of her phone calls with Scott were played for the jury across multiple sessions. Laci's family testified about her personality and her pregnancy and the plans she had made for her son. Friends and acquaintances described inconsistencies in Scott's behavior in the days following the disappearance, including a comment attributed to Laci's cousin about how Scott had shown more visible reaction to burned chicken at a barbecue than he had to his wife's disappearance. Investigators testified about the physical evidence, the boat Scott had purchased only weeks before Laci vanished, the location where the remains were found, the financial records and phone records, and security footage that traced his movements. The prosecution had no eyewitness to the murder, and no crime scene, no location where it had definitively taken place, no murder weapon. Their case was built on circumstantial evidence: the affair, the timing of the boat purchase, the location of the remains relative to where Scott said he had been, and the pattern of behavior he had exhibited throughout the investigation. The defense argued that Laci had been abducted by a third party after Scott left for the marina, pointing to a burglary that had occurred across the street from the Peterson home on the day of the disappearance, and arguing that investigators had focused too narrowly on Scott, while other possibilities went unexplored. After more than 5 months of testimony and evidence, The jury deliberated for 7 days. On November 12, 2004, they returned guilty verdicts on both counts: first-degree murder for the killing of Laci and second-degree murder for the killing of Conner. The distinction in degree between the two counts reflected the jury's reasoning about premeditation. Several months later, in March 2005, the same jury recommended a sentence of death. Judge Alfred DeLucchi formally imposed that sentence, and Scott Peterson was transferred to San Quentin State Prison, where California houses its male death row inmates, to await execution. For more than 15 years, the case moved through the appeals process that accompanies all capital sentences in California. It was an extraordinarily slow process, which is standard in death penalty cases, given the volume and complexity of appeals available and the stakes involved. Peterson maintained throughout that he had not killed Laci, and a small number of researchers and advocates took up his cause over the years, arguing that the evidence at trial had been insufficient to support conviction. His sister-in-law, Janie Peterson, became one of the most prominent voices advocating for a new trial, appearing in interviews and public forums to argue that the case had never adequately accounted for alternative explanations for Laci's death. In August 2020, the California Supreme Court issued a significant ruling in Peterson's case, but not one that touched his conviction. The court found that the trial judge had improperly excluded potential jurors during jury selection based on their views about the death penalty, excluding people who expressed reservations about capital punishment in ways that went beyond what the law permitted. This procedural error was serious enough that the court vacated the death sentence and sent the penalty phase back to a lower court for reconsideration. The conviction itself was left in place. Prosecutors in Stanislaus County subsequently announced in May 2021 that they would not seek a new death penalty proceeding against Peterson. Laci's family had indicated they did not want to go through another sentencing trial. In December 2021, Peterson appeared before a judge and was formally resentenced to life in prison without the possibility of parole. He was moved from San Quentin to Mule Creek State Prison in Ione, California, in October 2022. In January 2024, the Los Angeles Innocence Project announced it was taking on Scott Peterson's case. The organization, which represents people convicted of crimes who maintain their innocence and seek review of the evidence against them, indicated it believed there was material that had not been fully examined. A California judge subsequently granted the defense access to previously undisclosed evidence and authorized additional DNA testing on at least one item, a piece of duct tape found on Laci's clothing. In 2025, Peterson's legal team filed a new petition arguing, among other things, that updated forensic science placed Conner's date of death later than the prosecution had claimed at trial, potentially conflicting with the time frame the prosecution had built its case around. A judge reviewed those arguments and concluded that the science involved was not genuinely new, having been available in some form even at the time of the original proceedings. The petition was denied, and an appeal of that denial was filed. As of July 2026, Peterson is serving his life sentence at Mule Creek State Prison. He is 53 years old. His legal team continues to work through the California court system, seeking review of his conviction. Laci's family has not wavered in their belief that he is responsible for her death. Sharon Rocha, Laci's mother, has participated in documentary coverage of the case and has consistently maintained that the jury reached the correct verdict. The case continues to generate coverage and debate at a level that is unusual more than 2 decades after the crime. Whatever else is said about it, the basic facts that the courts established in 2004 have remained legally undisturbed. A jury of 12 people, after hearing months of evidence, found Scott Peterson guilty of killing his pregnant wife and their unborn son, and no subsequent court has overturned that finding. Laci was buried in Escalon, California. Conner was buried with her. The house on Covina Avenue in Modesto passed through other owners. The Berkeley Marina, where Scott said he spent that Christmas Eve morning fishing in a boat he had owned for less than a month, is still there. People still fish from it. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the Central Valley of California, we move next to a quiet suburb west of Boston, where a young British engineer and his American wife were trying to build a life together in a rented house in Massachusetts. They had a 9-month-old daughter, In January 2006, a family friend asked police to check on the household. What officers found, and where the only surviving member of that family had gone by the time they arrived, shapes one of the more quietly disturbing cases of this kind. Case 3. Neil Entwistle. Neil Entwistle was born in September 1978 in the market town of Worksop in Nottinghamshire, a working-class community in the English Midlands. His father was a coal miner and his mother worked as a school cook. He attended the University of York and proved to be academically capable, graduating with a master's degree in electronic engineering. He was thoughtful-looking, quiet in manner, and gave people who encountered him no particular reason for alarm. While studying at York, he met an American woman named Rachel Souza, who had come to England from Massachusetts on a study abroad program. Rachel had attended the College of the Holy Cross and was working toward a teaching certificate while spending time in the United Kingdom. The two became a couple, and when Rachel returned to the United States, Entwistle followed. They married in Plymouth, England, in August 2003. For a period, the couple lived in Worcestershire, in the west of England, where Rachel taught English, drama, and theatre studies at a Catholic secondary school in Redditch. In April 2005, Rachel gave birth to their daughter, whom they named Lillian Rose. She was by all accounts a healthy, cheerful infant. The family of three then made the decision to relocate to the United States, settling initially with Rachel's mother and stepfather, Priscilla and Joseph Matarazzo, in Carver, Massachusetts, while they looked for a place of their own. In January 2006, they signed a lease on the house in Hopkinton and moved in. It was a new beginning. That was how it was framed to the people around them, a fresh start in a new country, closer to Rachel's family, with better professional opportunities ahead for both of them. The reality of their financial situation was considerably more complicated. Neil had been unable to secure steady employment in the United Kingdom before they left, and after arriving in Massachusetts, he found no work either. He had attempted to generate income through a series of online businesses, most of which were either fraudulent schemes or ventures that promised more than they could deliver. He advertised services online involving software, adult content, and other products, collecting payments without providing what customers had paid for. He had also run what amounted to an escort service referral operation through the internet. The complaints were building. The money he was taking in was not enough, and the debts the couple had accumulated were serious. Investigators would later establish that in the days immediately before the murders, Neil had visited a website that described methods of killing people. He had also been browsing escort service listings. On January 20th, 2006, Rachel's mother, Priscilla Matarazzo, began trying to reach her daughter and couldn't. Friends of the couple also grew concerned over the following day when Rachel did not respond to calls or messages. She was known to be reliably in contact with the people close to her, especially her mother, and her sudden silence was troubling. On January 22nd, a friend asked Hopkinton police to check on the household. Officers conducted an initial sweep of the property and found nothing apparently amiss. They returned later that same day for a more thorough search. In the master bedroom, they found Rachel Entwistle lying in the bed, with Lillian next to her. Both had been shot. Rachel was 27 years old. Lillian was 9 months old. A .22 caliber handgun, registered to Joseph Matarazzo, Rachel's stepfather, was recovered at the scene. The gun had been stored at the Matarazzo home in Carver. Forensic examination of the weapon found Neil Entwistle's DNA on the grip and Rachel's DNA on the muzzle. Matarazzo had previously taken Entwistle to his shooting club and allowed him to handle the weapon. Investigators concluded that Neil had taken the gun from his in-laws' home without their knowledge at some point before the killings, used it, and then returned it. Keys to the Matarazzo house were later recovered from a car Neil had left at Boston's Logan International Airport. The sequence suggested deliberate preparation rather than impulse. A man who had obtained the weapon from a known location, used it, replaced it, and then moved. Because Neil Entwistle was not in Hopkinton when police arrived, he had left the country. At approximately 5 in the morning on January 21, the day after the deaths and before the bodies had been discovered, Entwistle had appeared at Logan Airport and purchased a one-way ticket to London on British Airways. The flight departed Boston at 8:15 in the morning. By the time officers entered the house in Hopkinton, Neil was already in England, staying at his parents' home in Worksop. When investigators reached him by phone, he told them he had returned to his parents because he had found Rachel and Lillian dead when he came home from running errands on January 20th, and that the shock had overwhelmed him to the point where he had fled without calling for help or telling anyone what he had found. He said he could not explain why he had not called the police. He said he did not know what had happened to them. That account almost immediately fell apart against the physical and forensic evidence. The DNA on the firearm placed him in direct contact with the weapon that killed his wife and daughter. The timing of his departure made clear he had taken a one-way flight out of the country within hours of the deaths. His computer had been searched in the days preceding the killings and showed a specific pattern of browsing that included the website about methods of killing people. There was no sign of forced entry at the Hopkinton house, no evidence of any intruder, and nothing that supported the defense position, which Entwistle's legal team would later advance at trial, that Rachel had shot Lillian and then turned the weapon on herself. The medical examiner's report on the positions of the bodies, the wounds, and the physical evidence at the scene was used by prosecutors to argue that the defense account was physically impossible. On February 8, 2006, Entwistle was arrested at his parents' home in Worksop by officers from the Metropolitan Police's extradition unit. His parents were present. He was held in British custody while the extradition process unfolded. He waived his right to contest the extradition and was returned to the United States on February 15, 2006, roughly 3.5 weeks after his daughters and wife had been found dead. He was arraigned at Framingham District Court and ordered held without bail at a jail in Cambridge. In March of that year, he was formally indicted on 2 counts of first-degree murder, along with charges related to illegal possession of the firearm and ammunition. He pleaded not guilty to all charges. In December 2006, jail officers at Middlesex County discovered letters Entwistle had written to his family and his legal team, in which he expressed that he was struggling and might be in danger from himself. Those letters became part of the record of his time in pre-trial custody. His trial did not begin until the spring of 2008, more than 2 years after the killings, as the legal process moved through its customary pace. The trial took place in Woburn, in Middlesex County. The prosecution laid out a case that centered on the forensic evidence from the gun, the circumstances of his departure from the country, the condition and location of the bodies, and the background of his financial situation. They presented testimony establishing the fraudulent nature of his online business activities and the debt he and Rachel had accumulated, framing the killings as the act of a man who could not face what his life had become and who chose to eliminate rather than confront it. A key component of the prosecution's argument was the timeline. Rachel's death had been caused by a contact gunshot wound to the head at close range, and Lillian, who had been lying beside her mother in the bed, had been shot as well. The prosecution argued that Neil had shot them both, returned the weapon to his in-laws' home, and then spent the remaining hours of that day and into the following morning preparing to leave. The defense built their case around the theory that Rachel had been suffering from postpartum depression and had reached a breaking point, shooting Lillian and then herself. They pointed to the physical location of the gun, which had been found in the bed near Rachel's body, and to the fact that Rachel's DNA was on the muzzle, which they argued was consistent with a self-inflicted wound. Several defense witnesses addressed the question of Rachel's mental state and the challenges she had faced as a new mother far from home. The defense also argued that the prosecution had not established beyond reasonable doubt that Neil was responsible for the deaths. The jury did not find the defense account persuasive. During deliberations, one juror later described to a television news program how the panel had worked through the physical evidence in detail, including an informal reenactment of aspects of the crime scene within the jury room itself. That process, she said, helped establish for the jury that the position and nature of the wounds were not consistent with Rachel having fired the weapon. Neil Entwistle was convicted of 2 counts of first-degree murder. The verdict carried mandatory life sentences without the possibility of parole under Massachusetts law, which does not have the death penalty. He was sentenced to 2 consecutive life terms. Entwistle's parents, Clifford and Yvonne, maintained after the trial that their son was innocent and that Rachel had killed Lillian and herself, leaving Neil to discover the bodies and then flee in shock. They pursued that position publicly for some time. Lillian's birth and death certificates were subsequently amended to list the father as unknown, a formal legal step that severed the documented connection between Neil Entwistle and the daughter he had been convicted of murdering. Over the years following his conviction, Entwistle pursued appeals through the Massachusetts courts. His automatic appeal was rejected in 2012. He subsequently filed additional petitions, including one to the United States Supreme Court, which also declined to take up his case. In August 2023, he filed a petition with the Massachusetts Supreme Judicial Court, arguing, among other things, that an informal reconstruction carried out by jurors during deliberations had denied him a fair trial, since it relied on information and analysis not formally introduced as evidence. Those arguments were reviewed and rejected. He remains incarcerated at the Old Colony Correctional Center in Bridgewater, Massachusetts. The house in Hopkinton was sold and eventually absorbed back into the neighborhood. The Matarazzo family, Rachel's parents, have lived with the awareness that the weapon used to kill their daughter and granddaughter had sat in their own home and had been handled by the man they had taken in as family. Rachel's death certificates, along with those amended records for Lillian, are part of the permanent public record of what happened in that house in January 2006. Neil was 27 when he flew out of Boston. He is now in his mid-40s, and he will spend the rest of his life in the Massachusetts prison system. One detail that stayed with people who followed the case closely over the years involves Lillian's birth and death. She was born in April 2005 and died in January 2006. She was 9 months old, not yet 1 year. The span of her life was so brief that many of the people who might have known her had barely had time to meet her. Her grandmother had driven to Hopkinton, hoping to check on her when she could not reach Rachel by phone. The family friend who first asked police to look in on the household had simply been worried that something might be wrong. They had no idea what they were walking toward. Whatever Neil Entwistle told himself about why he did what he did, whatever calculations he made about his debts and his failures and what he could not face, he made them in a house where a 9-month-old child was asleep in a bed beside her mother. That is where the story ends, and there is nothing that can be said about the motives or circumstances that changes that fact in any meaningful way. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the suburbs of Boston, we move west to the Oregon coast, where a young family of 5 had settled in a small town called Newport. In December 2001, the bodies of 3 small children began appearing in the waterways nearby, and the man who should have been searching for them was already thousands of miles away, living under a borrowed name on the beaches of Mexico. Case 4. Christian Longo. In the late autumn and early winter of 2001, a young family of 5 lived in an apartment not far from the bay. By the time Christmas arrived that year, 3 of the 5 were dead, and their bodies had been placed in the waterways around the town. The other 2 had already fled. Christian Michael Longo was born in January 1974 in Michigan and raised in the tradition of the Jehovah's Witnesses, a faith his family practiced seriously. His childhood was shaped by the structured expectations of that religious community, by door-to-door ministry work, by a clear sense of what a good life was supposed to look like and what it required. He was 19 years old in 1993 when he married Mary Jane Baker, who was 26. The marriage was early, and the financial foundation the couple tried to build beneath it was shaky almost from the start. Longo had a persistent difficulty holding a position between who he wanted to be seen as and what he was actually able to provide. He made financial commitments he could not meet. He took on debt. He presented himself to people around him as more successful and stable than he was, maintaining the performance of competence and prosperity, while the real numbers underneath told a different story. The couple had 3 children in relatively quick succession. Zachary was born first, and by late 2001 he was 4 years old. Sadie was 3. Madison was 2. Mary Jane raised the children largely at home while Longo worked, or tried to. He had held a position with a company that distributed newspapers and later tried to launch a business of his own, a venture that failed. He had accumulated significant credit card debt and had committed check fraud, passing counterfeit checks drawn on client accounts to cover expenses and maintain the appearance of a functioning financial life. He was caught, charged, and placed on probation. Around that same period, he was discovered to have been unfaithful to Mary Jane and was removed from the Jehovah's Witnesses congregation as a result of his conduct. He moved the family west, pawning Mary Jane's ring to cover the cost of gas for the journey. They settled in Oregon, first in Toledo and then in Newport, living in an apartment on the coast. By December 2001, the situation was deteriorating badly. The debt was severe. The relationship between the couple was under enormous strain. Mary Jane had family who had grown concerned about the stability of her life with Longo. He had been making inquiries about purchasing silencers for firearms, a detail investigators would later note when assembling a picture of the days before the killings. He was, by his own later admission, at a point where the web of fabrications and failures that had come to define his adult life had grown so entangled that he could not see a way through it. On or around the night of December 16, 2001, Longo killed his wife and their youngest daughter. He strangled Mary Jane to death inside the apartment. He strangled 2-year-old Madison as well. He placed both bodies into suitcases, weighted each with dumbbells, and loaded them into his car. He drove to the Embarcadero, the marina area along the bay, and disposed of the suitcases in the water. He then picked up his 2 older sleeping children from the apartment and drove them to a location near the Lint Slough, a waterway that feeds into the Alsea River estuary south of town. There, he took the lives of 4-year-old Zachary and 3-year-old Sadie separately, asphyxiating them, and left their bodies near the water. After that, Christian Longo drove toward the airport and began making arrangements to leave the country. He stole the identity of a man named Michael Finkel, a journalist who had written for the New York Times magazine, and used that name to construct a new version of himself. By Christmas Day, he was in Cancun, Mexico, staying at a hotel on the resort coast of the Yucatan. He told people around him that his name was Michael Finkel, that he was a journalist, and that he was traveling for work. He drank at beach bars and met other travelers, and moved through the easy social rhythms of a resort town where no one asked too many questions. The children he had left in the waterways of Newport were not yet in any news report. The disappearance of the family had not yet been noted by anyone outside their immediate circle. The first body was found on December 19th, 3 days after the killings. Zachary Longo, 4 years old, was found floating in the Lint Slough. Shortly afterward, Sadie's body was recovered from nearby water. Investigators began searching for the family. In late December, the weighted suitcases containing the bodies of Mary Jane and Madison were found floating in the water near the Embarcadero Marina. Mary Jane was 34, Madison was 2. The physical condition of the bodies and the method of disposal gave investigators a rapid and clear sense that this had been a deliberate act carried out by someone who had planned, at least in part, what they intended to do. The question was where Christian Longo had gone. The FBI placed him on their 10 most wanted fugitives list. The listing went public in early January 2002. At the time, Longo was still in Mexico, having moved south along the coast to the small town of Tulum, about 80 miles below Cancun. He had befriended travelers at his hotel and had continued presenting himself as Michael Finkel, weaving an account of his life as a magazine journalist that was detailed enough to sustain conversation. A hotel worker eventually recognized him from the FBI listing and alerted authorities. On January 13, 2002, Mexican police located and arrested Longo in Tulum without incident. He was taken into American custody the following day at an airport in Houston and transported back to Oregon. The real Michael Finkel had by this point been contacted by investigators and had learned that his identity had been stolen by a man accused of killing his wife and 3 children. Finkel, who had his own complicated circumstances at the time, involving a fabricated story that had led to his termination from the Times, eventually made contact with Longo during the pre-trial period. That correspondence and the series of conversations that followed over the subsequent months became the basis of a book Finkel wrote about the experience, published in 2005 under the title True Story. A film adaptation was released a decade later. The relationship between the 2 men, a journalist whose professional reputation had collapsed and a man on trial for the murder of his entire family, became one of the stranger subplots in a case that already had several. Longo's trial took place in Lincoln County, Oregon, in the spring of 2003. He chose to act partly as his own attorney during certain portions of the proceedings, a decision that gave him some ability to shape his own presentation before the jury. His account of the killings, which he offered from the witness stand, was this: that Mary Jane had, in a state of despair over the family's financial collapse, killed the 2 older children Zachary, and Sadie, herself. He claimed he had discovered this and had then, overwhelmed and broken, killed Mary Jane and Madison in some kind of reactive state that he characterized as merciful. He said he had not planned for any of it. He said the killings of the two older children had been Mary Jane's act, not his. The jury did not accept it. They deliberated for less than 4 hours. The physical evidence from the bodies, the manner in which the suitcases had been prepared and weighted, the timing and sequence of how the remains were disposed of across different locations, and the overall pattern of what had happened in the days surrounding the killings combined to undercut Longo's account thoroughly. He was convicted on 4 counts of aggravated murder. On April 16, 2003, he was sentenced to death on each count. The case drew sustained public attention, in part because of the Finkel book and later the film, and in part because of what Longo himself did from inside Oregon State Penitentiary in the years that followed. In 2009, he wrote an opinion piece for the New York Times, in which he argued that death row inmates should be permitted to donate their organs after execution, that the ability to give something back in that final act was something he personally wanted. He established an organization with the acronym GAVE, standing for Gifts of Anatomical Value from Everyone, intended to advocate for expanding organ donation eligibility to condemned prisoners. Whether this was a genuine expression of remorse or a calculated effort to extend his life through public attention and continued legal activity was a question that people who followed the case asked repeatedly, given that pursuing the organ donation campaign gave him reasons to delay his own execution. He admitted in a letter obtained by a Portland television station that he had come to recognize himself as a narcissist. Mary Jane's sister, Penny Dupuy, had spent years watching her family try to process the loss of her sister and 3 young children. She had developed, over that time, a settled and clear position on what should happen to Christian Longo. When the call came in December 2022, she was sitting at her desk at work in Arizona. The call was from a victim's advocate in Oregon. The news was that the outgoing governor of Oregon, Kate Brown, had signed an executive order commuting the sentences of all 17 people on Oregon's death row to life imprisonment without the possibility of parole. The announcement was made with very little advance warning to the families of victims. Dupuy described the moment as devastating. She had not had an opinion about the death penalty before her sister was killed. After it, she had developed one. She believed Longo deserved to die for what he had done. She did not believe the governor had the standing to override the exhaustive process, spanning a decade and involving a judge, a jury, prosecutors, defense attorneys, witnesses, and the families of 4 murdered people, with a signature. Governor Brown defended the decision publicly, describing capital punishment as immoral, inequitable, and irreversible. She argued it was a further step toward ending the use of the death penalty in Oregon. The order was not limited to Longo. All 17 sentences on death row, covering a range of cases and circumstances, were commuted at once. For the families of the people killed in each of those cases, the effect was the same. The sentence a jury had determined was appropriate was removed without their participation. Christian Longo is now in his early 50s. He remains incarcerated at Oregon State Penitentiary in Salem, where he is serving 4 life sentences without the possibility of parole. The children he killed were 2, 3, and 4 years old. Mary Jane was 34. The town of Newport, where the bodies were found in the waterways across those cold December days, has continued as it always has, a working harbour town shaped by the rhythms of the ocean, the fishing fleet coming and going, the salt air over the docks. The apartment where the Longo family lived no longer holds any particular trace of them. The slough where Zachary and Sadie were left is still there, feeding quietly into the estuary as it always has, the water moving as it always moves. The detail that tends to stay with people who spend time with this case is not the most dramatic one. It is not the stolen identity or the resort beaches or the organ donation campaign or the book. It is something more ordinary. Longo packed his 2 older children, Zachary and Sadie, into his car after killing their mother and their baby sister. They were asleep when he picked them up. There is no account of what they understood or did not understand. No record of what passed between them and their father in those final minutes. The drive to the Slough would not have taken long from the apartment. The town is not large. Whatever happened there Whatever the last moments of a 4-year-old and a 3-year-old looked like in the dark by a waterway in December exists in the record only as forensic fact and then as silence. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the Oregon coast, we move south and east to the suburbs of Columbia, South Carolina, where a single father was raising 5 young children on his own after a difficult divorce. In the summer of 2014, all 5 of those children were killed. The father drove with their bodies for 9 days across 4 states before a traffic stop in Mississippi ended it. What a jury in South Carolina decided about his fate is the next case. Case 5. Timothy Jones Jr. The neighborhoods in the areas around Red Bank and Lake Murray blend into one another across wide, flat roads, the houses sitting on modest lots with pickup trucks in the driveways and above-ground pools in the backyards. People who live there tend to work in Columbia or in the trades, and families spread across the surrounding communities in the way that working families do, connected by churches and schools and the ordinary traffic of everyday life. In August 2014, a man named Timothy Ray Jones Jr. was living in a mobile home off a dirt road in that part of Lexington County, raising 5 young children on his own. By the time anyone realized the children were gone, they had been dead for more than a week. Timothy Jones Jr. was 32 years old in the summer of 2014. He had grown up in South Carolina and had gone on to Mississippi State University, where he earned a degree in computer engineering in 2011. He found a position as an engineer with Intel in Columbia, earning around $70,000 a year, which was a solid professional foundation for a man his age in that part of the country. He had married a woman named Amber Kaiser when he was 22 and she was 18, and the couple had 5 children together over the years that followed. The oldest was a girl named Mira. Then came Elias, Natan, Gabriel, and Abigail, the youngest. When Jones and Kaiser divorced in 2013, the outcome of the custody arrangement was unusual. Jones was awarded full custody of all 5 children, and Kaiser was permitted only supervised visitation, typically arranged to take place at a Chick-fil-A in Lexington, where the children could be seen in a neutral setting. By the summer of 2014, Jones had left Intel and was no longer working. He and the 5 children were living in the mobile home on the dirt road, and the household had become increasingly disordered. People who knew him described a man whose behavior had grown erratic and whose thinking had become difficult to follow. He was using synthetic marijuana and alcohol. He had developed beliefs about those around him that were not grounded in what was actually happening, including a conviction that his ex-wife had been unfaithful and that certain of the children might not be biologically his. He had paternity testing done on the children at some point during the marriage, which confirmed he was the father of all of them. That confirmation had not resolved his preoccupation with the question. In his confession to investigators, Jones described working 6-year-old Natan to death, a phrase that implied the boy had been subjected to physical punishment of an extreme nature. He then killed the other 4 children in what he characterized as a panic. The killings took place inside the mobile home across the weekend of August 28th and into the following days. Mera was 8, Elias was 7, Gabriel was 2, Abigail was 1 year old. The details of how each child died were established through autopsy findings and Jones's own statements to police. He strangled Elias with his hands. He chased Mera through the home before choking her. He used a belt on Gabriel and Abigail because, as he told investigators, his hands were too large to wrap around their necks effectively. After all 5 children were dead, Jones put their bodies into black plastic garbage bags and loaded them into the trunk of his Cadillac Escalade. He then drove. For 9 days, from early September onward, he moved through South Carolina, Georgia, Alabama, and Mississippi with the bodies of his 5 children in the car. He stopped at gas stations and stores along the way. He purchased bleach and other items. Witnesses at some of the stops later told investigators that the vehicle had smelled strongly of decomposition and bleach, a combination that lingered in the memory of at least one person who had been near the car. Jones told some people he encountered that the bags in the trunk contained dead animals. He drove with no apparent destination and no apparent plan. On September 6th, a deputy in Smith County, Mississippi, conducted a traffic stop on the Escalade. The stop was routine initially, prompted by a traffic violation. When the deputy approached the vehicle, he noted the strong smell from the trunk and observed blood and drug paraphernalia visible inside the car. Jones was arrested for driving under the influence and drug possession. He was taken in, and once in custody, he told officers what was in the trunk. He then led investigators to a remote location on a hillside in Wilcox County, Alabama, where he had left the bagged remains of his children in the days before the Mississippi traffic stop. DNA testing confirmed the identities of all 5 children. Amber Kaiser had reported her children missing on September 3rd, 3 days before the traffic stop, after Jones failed to produce the children for a scheduled visitation and stopped answering her calls. She had contacted authorities that day to report that she could not reach him or the children. Investigators listed the family as missing but did not immediately issue an Amber Alert, citing the fact that Jones was the custodial parent. The public was not notified until several days later, by which point the bodies had already been found. Jones was returned to South Carolina and charged with 5 counts of murder. The case moved toward trial over the following years. By the time proceedings began in May 2019, the case had become one of the most closely watched in the state's recent history. Jones pleaded not guilty by reason of insanity, with his defense team arguing that he suffered from a serious mental illness that had stripped him of the capacity to understand that what he was doing was morally and legally wrong. They described a man who had been deteriorating for an extended period, whose behavior had become increasingly delusional, and who had been self-medicating a diseased mind with substances that accelerated its collapse. They asked the jury to consider whether the man who carried those bags to that Alabama hillside had any meaningful understanding of what he had done. The prosecution's position was straightforward. In his closing argument, the lead prosecutor walked the jury through the series of decisions Jones had made across the days surrounding the killings: the preparation of the bags, the loading of the bodies, the purchases at the Walmart in West Columbia, where he had bought plastic bins and cleaning supplies, the 9 days of driving through 4 states with the children in the trunk, the stories he told to people he encountered along the way. Each of those decisions, the prosecution argued, represented a deliberate act by a man who understood what he had done and was trying to prevent its discovery. A man who did not understand the wrongfulness of his actions, they argued, does not spend 9 days driving through the American South trying to dispose of the evidence. The trial included testimony from multiple forensic psychologists and psychiatrists, who offered sharply conflicting assessments of Jones's mental state. The defense experts described genuine and severe psychopathology. The prosecution experts described a man whose dysfunction, while real, did not meet the legal threshold for insanity, which in South Carolina requires that a defendant be unable to distinguish moral or legal right from moral or legal wrong at the time of the crime. After 15 days of testimony, the jury deliberated for 6 hours across 2 days before returning guilty verdicts on all 5 counts of murder. The sentencing phase followed separately. The jury was presented with arguments about aggravating and mitigating factors. The prosecution offered the nature and number of the crimes and the youth of the victims. The defense offered the mental health evidence again and asked for mercy. The same jury that had found Jones guilty deliberated again and determined that an aggravating circumstance existed. On June 13, 2019, Timothy Jones Jr. was sentenced to death on 5 counts of murder. He was one of only 2 people sentenced to death in South Carolina that year. The cost to Lexington County of the trial alone, according to public records, was reported as more than $600,000. Jones's legal team filed an appeal with the South Carolina Supreme Court in 2021, raising 8 separate issues. These included questions about juror qualifications during selection, the handling of certain voir dire requests, jury instructions related to the insanity verdict, and several evidentiary rulings made during both the guilt and sentencing phases. The appeal was argued in November 2021. In March 2023, the court issued its opinion affirming both the conviction and the death sentence. The justices found that while the trial court had made certain evidentiary errors, those errors were harmless and had not affected the outcome. The death sentence remained in place. Jones is currently held at Kirkland Correctional Institution in Columbia, South Carolina, which houses the state's death row. South Carolina had not carried out an execution since 2011, a gap that resulted from the state's inability to obtain the drugs used in lethal injection protocols. In recent years, the state legislature authorized electrocution and firing squad as alternative methods, and South Carolina resumed executions in 2024. Jones's case continues to move through the appellate process that follows all death sentences, and no execution date had been set as of mid-2026. Amber Kaiser, the children's mother, has spoken publicly about the case on several occasions in the years since the trial. She described the divorce, the custody arrangement, and the visits at the Chick-fil-A that she and the children shared in the period before the killings. She described Mera as a protective older sister, Nathan as lively and curious, Gabriel and Abigail as still small enough to be carried. She has also said that she did not hate Jones, which is perhaps the most difficult thing anyone has said publicly about this case, because it opens a window into a kind of grief that refuses simple categories. What she lost on those days in late August 2014 is not something that resolves into a clean emotion or a single verdict. Timothy Jones Jr.'s father, Timothy Jones Sr., was the subject of documentary coverage in 2026, exploring the experience of a parent watching their own child face execution for the murders of their grandchildren. That particular dimension of the case, the generational depth of what a familicide leaves behind, is rarely part of the public accounting of these crimes. The focus falls on the perpetrator and on the victims, the people in between, the parents of the man who did it, the grandparents of the children who were killed, tend to exist at the edges of the frame. The mobile home off the dirt road in Red Bank is gone from the record in any meaningful sense. The 5 children are buried. The Alabama hillside where their remains were found beside a rural road is a place that most people will never visit and could not find on a map. What remains formally is the case file, the conviction, the sentence, and the fact of 5 children who lived for between 1 and 8 years and whose father put them in garbage bags and drove them through 4 states in the heat of early September. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From South Carolina, we move to Dallas, Texas, and a May evening in 2001, when a father had his 2 young daughters over for a scheduled visit at his apartment. Their mother was on the phone with the older girl when the call became something she would spend the rest of her life trying to forget. That father spent 16 years on death row before the state of Texas ran out of patience with his legal maneuvers. Case 6, John Battaglia. In the spring of 2001, a 62-year-old accountant named John David Battaglia was living in a loft apartment in a building called the Adam Hatz Lofts in the city's uptown neighborhood, a refurbished former commercial building in a part of Dallas that had been attracting younger professionals and creative types through the 90s and into the new century. He had 2 daughters from his second marriage, 9-year-old Faith and 6-year-old Liberty, and on the evening of May 2nd, 2001, both girls came to his apartment for a scheduled visit. Their mother, Mary Jean Pearl, dropped them off and left. She would never see them alive again. Battaglia had spent the years of his adult life accumulating a record of domestic violence that had moved through 2 marriages and left a paper trail of court filings, protective orders, and criminal charges. His first wife, Michelle Getty, an attorney, had been the target of repeated physical assaults during their marriage and in the period following their separation. He had struck her outside the school attended by their daughter Christy from that relationship, causing injuries serious enough to require hospitalization. He had attacked her at a bus stop. He had been charged with misdemeanor assault and placed on probation for 2 years in 1987. That probation had not changed his behavior in any lasting way. His second marriage, to Mary Jean Pearl, followed a similar trajectory. Pearl later testified and gave public accounts of the violence she experienced during their years together and the fear that became a permanent part of her life once she understood who she had married. The couple divorced, and Pearl retained primary custody of Faith and Liberty. Battaglia's relationship with his daughters, whatever its nature in private, was officially maintained through scheduled visitation. In the period leading up to May 2001, the relationship between him and Pearl had reached another point of legal tension. Around Easter of that year, Battaglia had left an angry and profane voicemail message for Pearl. When she reported the message to his probation officer, as she was entitled to do, the probation officer began reviewing whether Battaglia should be considered for revocation of his probation. On the afternoon of May 2nd, Battaglia learned that a warrant had been issued for his arrest in connection with that review. A police officer contacted Battaglia that afternoon and told him he could make arrangements to turn himself in peacefully and that the arrest would not take place in front of his children. Battaglia had a scheduled dinner visit with Faith and Liberty that same evening. Pearl brought the girls to the apartment and left, unaware of the warrant or of the calls that had taken place that day between her ex-husband and law enforcement. Once the girls were inside, Battaglia called Pearl on the telephone. He put the call on speakerphone and instructed Faith to ask her mother why she wanted their father to go to jail. Pearl, on the other end of the line, tried to speak to both Battaglia and to the girls. She told the girls to run for the door. What she heard next, transmitted across that open speakerphone line, was Faith telling her father not to do it, begging him to stop, and then the sound of gunshots, then silence, followed by Battaglia's voice making a comment directed at Pearl before firing again. Pearl hung up and called the police. When officers arrived at the Adam Hatz lofts, they found Faith and Liberty dead inside the apartment. Both had been shot. Battaglia was gone. He had left the building after the shootings, gone to a bar with a woman he had been seeing, and then visited a tattoo parlor where he had 2 roses tattooed on his left bicep, one for each daughter. He was arrested the following day. During the arrest, he fought back against multiple officers and was carrying a loaded revolver. 16 firearms were later recovered from the apartment. He was taken into custody with a black eye sustained during the struggle with arresting officers. Battaglia's capital murder trial began in April 2002 at the Frank Crowley Courts building in Dallas. The prosecution's case required very little assembly. Pearl had been on the phone. She had heard her daughters die. The physical evidence at the scene was unambiguous, and Battaglia's movements in the hours after the killings, the bar, the tattoo parlor, the loaded weapon he was carrying when arrested, painted a picture of a man who had done what he had done and had then proceeded through the evening without significant apparent distress. The jury deliberated for 19 minutes before returning a guilty verdict on the capital murder charge. The same jury recommended a sentence of death, and that sentence was formally imposed. What followed was one of the longer and more procedurally complicated journeys through the death penalty appeals process in Texas in recent memory, and it centered almost entirely on the question of whether John Battaglia was mentally competent to be executed. Under a precedent established by the United States Supreme Court, the state cannot execute a person who does not have a rational understanding of the reason they are being put to death. Battaglia's legal team argued for years that he had developed a severe delusional disorder that rendered him unable to meet this standard. They presented testimony from psychologists who had examined him and concluded that he believed his situation was the product of a vast conspiracy involving his former wives, his attorneys, the prosecutors, the trial judge, the jury, and the Ku Klux Klan, and that he had no genuine understanding of the connection between the murders he had committed and the execution that awaited him. 3 of the 4 psychologists who formally examined Battaglia in connection with competency hearings concluded he was not fit for execution. The Texas courts reviewed the question across multiple proceedings over more than a decade. Execution dates were set and then halted. In March 2016, the scheduled execution was stopped just hours before it was due to take place, when the United States Court of Appeals for the Fifth Circuit intervened to allow the mental competency claim to be developed more fully. A state court held hearings and found him competent, relying in part on recorded phone calls between Battaglia and his father, in which Battaglia referred to the death penalty process as a chess game and discussed which legal moves might extend his life. The judge who reviewed the competency question described him as highly intelligent, educated to a master's degree level, and capable of deliberate strategic behavior, all of which pointed away from genuine incompetence and toward calculated performance. That finding was appealed to the Texas Court of Criminal Appeals, which issued a lengthy opinion affirming that Battaglia was competent to be executed, rejecting the defense argument that his delusional beliefs had prevented him from rationally understanding his situation. A second execution date was set for February 1, 2018. On the day itself, Battaglia's attorneys filed a final appeal challenging the drugs to be used in the lethal injection, arguing that previous executions in Texas had used expired and relabeled pharmaceutical compounds, and that Battaglia faced a risk of unconstitutionally cruel punishment as a result. That appeal moved through courts with extraordinary speed, as last-day appeals in capital cases typically do, and was denied at each level, including by the United States Supreme Court, which declined to intervene. The execution proceeded that evening at the Huntsville State Penitentiary, delayed by several hours due to the appeals process. When the warden asked Battaglia whether he had a final statement to give, he declined to offer one formally. Instead, he addressed Mary Jean Pearl, who was watching through the witness window with members of her family. The words he chose, his last before the lethal injection took effect, were a casual and dismissive greeting directed at her by name, followed by a comment suggesting he would see her and the girls later, followed by an instruction to proceed. He was pronounced dead at 9:40 in the evening. He was 62 years old. Faith had been 9 when he killed her. Liberty had been 6. Mary Jean Pearl had spent nearly 17 years moving through the legal process that followed the night she heard her daughters die over a telephone. She had campaigned against the Dallas County family court judge who had dismissed a prior assault charge against Battaglia before the murders, a judge who subsequently resigned from the bench and lost a bid for district attorney, partly because of her advocacy. She had testified. She had attended hearings. She had watched execution dates come and then be postponed. When February 1, 2018 finally arrived, it was the end of something that had consumed an enormous portion of her life since that May evening in 2001, when she told her daughters to run for the door. Faith and Liberty Battaglia were buried at Hillcrest Cemetery in North Dallas. Their funeral had been held at a Lutheran church in the neighborhood where they had grown up. The Adam Hatz Lofts building still stands in uptown Dallas. The roses Battaglia had tattooed on his arm on the night of the murders were still there when he died. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From Texas, we travel to Fresno, California, and a March afternoon in 2004, when police responded to what they believed was a custody dispute at a house in a quiet residential neighborhood. What they found inside that house when they were finally able to enter it remains the worst mass murder in Fresno's recorded history, carried out by a man who had spent years turning his family into something that had no name in ordinary life. Case 7, Marcus Wesson. On a residential street called Hammond Avenue in that part of Fresno, a large and unusual household had existed for years without drawing more than occasional notice from the surrounding neighborhood. The people inside rarely came out. The curtains stayed drawn. Children were sometimes heard but rarely seen. On March 12, 2004, 2 women knocked on the door of that house wanting their children back. By the time police were able to enter the building, 9 people were dead inside, piled in a back room, and the man who had controlled every dimension of their lives was standing outside with blood on his clothing. Marcus Delon Wesson was born in Kansas City, Missouri, in August 1946, the eldest of 4 children. His mother raised him in the Seventh-day Adventist Church, and he described her later as religiously extreme in her expectations. His father was an alcoholic who left the family when Wesson was young. After dropping out of high school, he joined the United States Army and served from 1966 to 1968, including a deployment in Vietnam as an ambulance driver. Shortly after leaving the military, he moved in with an older woman named Rosemary Solorio and her 8 children in San Jose, California. He was in his early 20s. Over the years that followed, he began a relationship with Rosemary's daughter, Elizabeth, who was a teenager at the time, and eventually had children with her. Elizabeth became, in the structure he would build around himself over the following decades, something between a wife and a subject. The household Wesson constructed across his adult life was unlike anything that had a conventional name. He kept multiple women, drawn from his own children and from the children of Rosemary Solorio, in relationships with him that produced children of their own. The children fathered through those incestuous arrangements were raised within the household under his absolute authority. He controlled what the family ate, how they dressed, where they went, and what they were permitted to believe. He had developed his own theology, a framework built from elements of Christianity, his own writings, and a fixation on vampirism as a metaphor for spiritual life. He wrote his own religious texts. He taught his children that Jesus Christ had been a vampire, that drinking blood was connected to eternal life. He presented himself as a messianic figure whose authority over the family was divine in origin. When he watched television news coverage of the 1993 federal siege of the Branch Davidian compound in Waco, Texas, he pointed to the screen and told his children that this was what happened when the outside world attacked God's people. He purchased more than a dozen antique caskets in the months before the Fresno killings, telling the family they were useful for wood and for sleeping. Several of the children had, at various points, slept in them. He had also prepared his family for the scenario that played out on March 12. For years he had told his children that if anyone from the outside world, particularly from government agencies or law enforcement, attempted to break the family apart, they were all to go to heaven together, rather than be separated. He framed it in the language of his theology, as a righteous act, a refusal to allow the world to destroy what God had made. The children had been raised inside that framework since infancy, and for most of them, it was the only framework they had ever known. The two women who arrived at the Hammond Avenue house that morning were Safina Solorio and Ruby Ortiz, nieces of Wesson through the Rosemary Solorio connection, both of whom had at various points been drawn into his household and had produced children with him. They had come because they had learned Wesson was planning to move the family to Washington State, and they feared losing all contact with their sons. They wanted their children. Neighbors later recalled hearing the argument at the door. Police were eventually called, and officers arrived to find Wesson blocking the entrance to the house. While police stood outside trying to manage the situation, the sound of a single gunshot came from inside the building. Wesson then emerged from the house. He walked past the officers calmly and sat down on the curb. His clothing had fresh blood on it. He did not speak in any meaningful way to the officers around him. When police finally entered the house, they found the 9 bodies in a back bedroom, piled together in a heap. 2 of the dead were adults. 7 were young children, 3 of whom were under 2 years old. Each had been shot once, through the right eye, with a single .22 caliber bullet. The weapon, a handgun belonging to Wesson, was found in the room near the body of his 25-year-old daughter, Sabrina, who was among the dead. Sabrina's DNA was on the gun. The investigation that followed established the full dimensions of what had existed inside that house across many years. Investigators interviewed surviving family members, examined financial records, reviewed the household's history across multiple California addresses, and built a picture of the internal structure Wesson had maintained. The sexual abuse of daughters and nieces had begun when they were children. One of the nieces, Ruby Ortiz, testified that Wesson had begun molesting her when she was 8 years old, telling her it was a father's way of showing affection. When she was 13, he told her she was old enough to marry him and invoked religious language to explain why it was appropriate. Ortiz had a son with him. Other daughters and nieces had children with him as well, a pattern that had continued across more than 2 decades. At trial, Wesson's defense team argued that Sabrina had fired the shots herself, killing the other children and then herself, in a desperate and unstable act that her father had not ordered or anticipated. They pointed to the gun's location, the DNA on the weapon, and the absence of gunpowder residue on Wesson's hands as physical evidence consistent with that account. The prosecution acknowledged that Sabrina may have held the weapon and fired the shots. Their argument was that Wesson had created the conditions that made the outcome inevitable, that he had spent years building a closed world in which his children had been trained to understand collective death as a sacred response to outside intervention, and that when the moment arrived, Sabrina had done what she had been raised to do because her father had made her into someone who would. The jury convicted Wesson of 9 counts of first-degree murder on June 17, 2005. In reaching that verdict, they rejected the notion that the killings were Sabrina's act alone and accepted the prosecution's theory that Wesson bore criminal responsibility for what had happened, regardless of who had physically held the gun. He was also convicted on 14 counts of forcible rape and sexual molestation involving 7 of his daughters and nieces. On June 27, 2005, he was sentenced to death. The Fresno mayor at the time of the killings, who had served as police chief when the case broke and had been among the first senior officials to view the crime scene, said publicly in the years that followed that he believed Wesson deserved to be executed and that nothing about his continued survival in prison served justice. That sentiment was shared by many in Fresno who remembered the morning the story emerged. The images of a large man sitting calmly on a curb, while 9 people he had claimed to love lay shot inside a house he had turned into something entirely his own. In March 2019, Governor Gavin Newsom signed an executive order placing a moratorium on all executions in California for the duration of his time in office. The order covered all of the state's more than 700 death row inmates, including Marcus Wesson. California subsequently began a process of dismantling the physical infrastructure of death row at San Quentin State Prison and transitioning condemned inmates into the general maximum security prison population under different housing conditions. Wesson, now 78 years old, remains in the California prison system. He will almost certainly die there, whether or not a formal execution ever takes place. The 9 people he raised and then arranged to have killed, the oldest of whom was 25, and the youngest of whom had not yet learned to walk, are buried. The house on Hammond Avenue was eventually demolished. A vacant lot stands in its place. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the heat of Fresno, we travel to a rural township southeast of Cincinnati, Ohio, where a father came home from work early one afternoon in June 2023, took a nap with his 3 young sons, and then retrieved a rifle from a gun safe. What happened in the yard of that house over the next few minutes, and what the boy's mother did to try to stop it, is the next case. Case 8, Chad Dorman. In the summer of 2023, a family of 5 lived on a property in Monroe Township. A father, a mother, 3 sons, and a teenage daughter from the mother's prior relationship. On the afternoon of June 15th, that household became the site of a crime so direct and deliberate that the prosecutor who described it in court could find no other word for it than execution. Chad Dorman was 32 years old in June 2023. He had grown up in the area and was known to people around him as a family man, a father who took his sons fishing and to baseball fields, and who appeared, from the outside, to be raising his children in the ordinary rhythms of rural Ohio life. He and his wife Laura had 3 boys together: Clayton, who was 7, Hunter, who was 4, and Chase, who was 3. Laura also had a teenage daughter from a previous relationship who lived in the household. By the accounts that emerged after the events of June 15, the family was not experiencing any obvious external crisis. There had been no recent public conflict, no dramatic change in circumstances that the people around them could point to afterward and identify as a warning. What Chad Dorman had been carrying internally in the weeks before that afternoon was not visible to anyone outside the house. He later told investigators that he had been thinking about killing his sons for months. He said the weight of those thoughts had been so constant and so heavy that he had not slept properly in 3 or 4 days before June 15. On the afternoon of that day, he came home from work earlier than usual. The account of what happened next was read into the court record by Claremont County Prosecutor Mark Tekulve at the August 2024 sentencing hearing, drawn from investigative findings and Dorman's own admissions. After coming home, Dorman lay down with all 3 boys in the master bedroom and napped with them. When he got up, he went to a gun safe, removed a rifle and loaded it. He then walked to where the boys were and shot Hunter twice. Hunter was 4 years old. He was in the bedroom with his mother. Laura Dorman heard the shots and ran to Hunter. She began trying to help her 4-year-old son and called out to the other 2 boys to run. Her teenage daughter, who had been watching television in another room, heard the shots and came to the doorway of the bedroom in time to see what had happened to Hunter. Clayton, who was 7, fled through the back door of the house and ran. Dorman followed him outside and shot him multiple times across the yard. The teenage girl followed them outside. She found Clayton on the ground, still alive, and watched from a short distance as her stepfather walked up to the boy and fired a bullet into his head. Dorman then turned toward the house. The teenage girl ran back inside and picked up 3-year-old Chase, trying to get him away from what was happening. Dorman came back into the house and found them. He told the teenager to put Chase down, threatening to shoot her if she did not. She held Chase for as long as she could, trying to protect him. Eventually, in the account given by the prosecutor, she had no choice but to set the boy down. Dorman pointed the rifle at Chase and pulled the trigger. The gun misfired. He pointed it again and fired. Chase was 3 years old. he died at the scene. Laura Dohrmann had by this point been shot in the thumb. She had, at some point during the events, pressed her thumb into the barrel of the rifle in an attempt to prevent it from firing. The prosecutor described that act in court with a particular precision. There was nothing, he said, that Laura Dohrmann could have done differently that would have saved her sons. She had stood between her children and a loaded weapon and done what any mother would do, and it had not been enough, because nothing would have been enough. Dohrmann had brought the rifle out with a purpose he had been carrying for months, and he pursued it to its end. When deputies arrived at the property, Chad Dohrmann was sitting on the steps of the house. The rifle was next to him on the stoop. He made no attempt to flee or resist. When officers approached him, he told them he had done it and asked to be taken to jail. All 3 boys were dead at the scene. Laura and her daughter were transported for medical treatment. Laura's thumb injury, caused by her attempt to block the rifle barrel, required treatment but was not life-threatening. Her daughter was physically unharmed. Dohrmann was initially charged with 9 counts of aggravated murder, along with additional counts of kidnapping and felonious assault, a total of 21 charges. He had been pursuing a not guilty by reason of insanity plea in the months following his arrest, and his defense team had been building a case around his mental state at the time of the killings. In the summer of 2024, however, both sides reached a plea agreement. Prosecutors agreed to drop the aggravating factors that would have made Dohrmann eligible for the death penalty, and he agreed to plead guilty to 3 counts of aggravated murder and 2 counts of felonious assault. The surviving members of the family had been central to that decision. Prosecutor Tekulve said publicly that his job, as he understood it in the week before the plea was finalized, was to relieve Laura Dohrmann and her daughter of the additional suffering that a full capital trial would have required them to endure. Putting them through months of proceedings in which the events of June 15 were examined in forensic detail would, in his words, have been an act of cruelty toward people who had already experienced something unimaginable. On August 2000, 2024, Judge Richard Ferentz of the Claremont County Common Pleas Court sentenced Chad Dohrmann to 3 consecutive life terms without the possibility of parole for the murders of Clayton, Hunter, and Chase. He also received 16 additional years for the 2 felonious assault counts. Tekulve told reporters outside the courthouse that Dohrmann would die in prison and that this was the outcome the case required. Victim impact statements were read in court before the sentencing. Laura Dohrmann's statement was read by a prosecutor on her behalf. She described what her household had been before June 15 and what it was afterward. She described the noise of 3 small boys filling a house, the ordinary sounds of children growing up, and the silence that replaced it. She said grief would never go away because it was all the love that had nowhere left to go. She said no punishment would bring her boys back, and that the guarantee of a life sentence was what her family needed to begin whatever came next. She asked those who had followed the case to remember Clayton, Hunter, and Chase as the boys they had been before that afternoon, the ones who loved fishing, who went to baseball fields, who swam in summer and ran around outside in the way that small children do when they have space and time and a world that has not yet closed in around them. Her teenage daughter's statement was also read in court. She said it was painful to watch Dohrmann go to prison because she had never expected him to do what he did. She said she could not hate him even though he had destroyed the family. She said holidays would never be the same. She said he had taken her brothers and that she would carry that forever. Dohrmann's own defense attorney acknowledged in his remarks before sentencing that his client had failed to address serious mental health issues that had built across years and that he understood there was no adequate explanation for what had happened. The judge imposed the sentences without extensive additional comment, noting only the horrible nature of what had been done and the setting in which it had been done, the family's own home, a place that should have been the opposite of what it became on June 15, 2023. Clayton Dohrmann was 7, Hunter was 4, Chase was 3. Their mother had pressed her thumb into a rifle barrel trying to keep them alive. Their stepsister had held their youngest brother and refused to put him down until she had no other choice. Those facts are part of the permanent record of what happened in Monroe Township on an ordinary summer afternoon, and they will remain there regardless of what Chad Dohrmann does or says or becomes during the decades he will spend in the Ohio prison system before he dies. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From rural Ohio, we move back in time to a Victorian mansion on a quiet street in Westfield, New Jersey, and the autumn of 1971. A Sunday school teacher and accountant shot 5 members of his family, wrote a careful letter explaining his reasons, turned the house lights on, set the intercom to play organ music, and disappeared. He would not be found for 18 years. Case 9. John List. In the autumn of 1971, a house at 431 Hillside Avenue in Westfield was one of the most distinctive properties in the borough. A 19-room Victorian mansion called Breeze Knoll, with a ballroom, marble fireplaces, and a Tiffany glass skylight in the entrance hall. It was the kind of house that announced something about the family inside it, that they had arrived at a certain station in life, that they were people of substance and standing. The reality inside the house was almost precisely the opposite of that announcement, and on the morning of November 9, 1971, the man who lived there made a decision about how to manage that gap that would not be discovered for nearly a month. John Emil List was born in September 1925 in Bay City, Michigan, and raised in a devout Lutheran household. He served in the United States Army during the Second World War and the Korean War, reaching the rank of first lieutenant, and then built a career in accounting and financial management that carried him through a series of corporate positions across the Midwest and eventually to the East Coast. He was methodical and careful in his professional manner, a man who dealt in numbers and balances and the orderly management of financial systems. He was also a devoted churchgoer who taught Sunday school, a fixture in the Lutheran congregations he joined in each community where the family lived. He was, in the portrait assembled by neighbors and colleagues who knew him, almost aggressively ordinary, a man who mowed his lawn in a suit and tie, who showed up reliably, who gave people around him nothing in particular to think about. He married Helen Morris Taylor in 1952. Helen had been previously married and had a daughter from that relationship, a stepdaughter named Brenda, who was part of the household for a time before eventually marrying and leaving. Helen was an alcoholic, a condition that had worsened steadily across the years of their marriage. She had also contracted syphilis from her first husband before marrying List, a fact she had not disclosed to him before they wed, and the untreated disease had progressed across decades to the point where it was affecting her neurological function in the early 1970s. John's mother, Alma List, was also part of the household at Breeze Knoll, an elderly woman who had moved in with the family. The 3 children List and Helen had together were John Jr., who was 25 by 1971 and was the oldest and had some independence, and 2 younger children, Frederick, who was 13, and Patricia, who was 16. In the autumn of 1971, the household at Breeze Knoll consisted of John List, Helen, Alma, Frederick, and Patricia. The financial reality of the family's situation had been deteriorating for some years. List had lost a position at a bank in Jersey City in the late 1960s and had not found comparable employment since. Rather than tell his family, he had continued leaving the house each morning as though going to work, spending his days at the Westfield train station, reading newspapers, riding trains, and sitting in public places while the hours passed. He had been quietly diverting money from his mother's bank accounts to cover the mortgage and household expenses, a form of financial fraud carried out against an elderly woman who trusted him. The mortgage was in serious arrears. The utilities were threatened. The accumulated debts had reached a point where List could see no path through them that did not require him to face something he had spent years arranging his life to avoid facing. Patricia, his 16-year-old daughter, had become involved in theatre and was moving toward a social world and a set of artistic interests that List experienced as a threat to her moral character and spiritual safety. He expressed concern about the direction her life was taking. He worried about his children's souls, about whether the pressures and moral environment of the world they were growing up in would compromise their standing before God. This concern, combined with the financial crisis he had concealed from everyone around him, appears to have formed the framework through which he justified what he planned. He wrote a 5-page letter addressed to his pastor, a Reverend Eugene Raywinkle, at the Redeemer Lutheran Church in Westfield, explaining what he had done and why. The letter described his financial situation, his fears about his family's spiritual well-being, and his conclusion that by taking their lives he was sending them directly to heaven, sparing them from a world that would otherwise corrupt or diminish them. He expressed his belief that he himself would face judgment for his actions, but expressed hope for eventual forgiveness. On the morning of November 9, 1971, List shot his wife Helen in the kitchen of the house at Breeze Knoll with a 9mm pistol. He then went upstairs and shot his mother Alma in her sitting room. He returned downstairs and waited. When Frederick came home from school in the afternoon, he shot him. When Patricia arrived home later, he shot her as well. His son John Jr. was not at the house that day and was not killed. List then carefully arranged the bodies of his wife and children on sleeping bags in the ballroom of the mansion. He left his mother where she was, upstairs, because her body was too heavy for him to move. He placed the letter for his pastor on a counter in the house. He cancelled the family's newspaper and milk deliveries and left notes with various community contacts explaining that the family would be away for an extended period. He turned on all the lights in the house and set the intercom system to pipe organ music through the rooms. He then walked out the front door and drove away. He was not seen again for 18 years. The family was reported missing to the Westfield Police Department in December 1971, after neighbours and community contacts grew concerned about the house remaining closed up for weeks with the lights constantly on. On December 7th, more than 3 weeks after the killings, police entered Breeze Knoll and found the 5 bodies. The organ music was still playing over the intercom. The letter was recovered. John List's car was found at John F. Kennedy International Airport in New York, suggesting he had boarded a flight, but investigators found no record of where he had gone or under what name. All usable photographs of List had been destroyed before he left. The trail, from the moment it was picked up, went almost immediately cold. List had driven to Colorado, where he assumed a new identity under the name Robert Peter Clark. He found work as an accountant, which was his actual profession, in Colorado, and later relocated to Richmond, Virginia. In 1977, he married a woman named Dolores Miller, who knew him only as Robert Clark and had no knowledge of his actual history. He joined a Lutheran church in the Richmond area, attended services regularly, and built the same surface of ordinary suburban respectability he had maintained in Westfield. For the people who knew him in Virginia as Robert Clark, he was a quiet, church-going accountant with conventional habits and no visible past. No one looked closely. The case had effectively stalled by the mid-1980s. New Jersey investigators had pursued hundreds of leads over the years without result. The America's Most Wanted television program, which began airing in 1988 on the Fox network, became a resource for law enforcement agencies attempting to generate public attention for cold cases. In May 1989, the program devoted a segment to the List murders, including a forensic clay sculpture created by an artist named Frank Bender, who had studied available photographs and physical descriptions to construct what John List might look like after 18 years of aging. Bender's bust was a striking piece of forensic artistry, and when it appeared on television, it generated an immediate response from a viewer in Richmond, Virginia, who recognized the features as resembling those of her neighbor, Robert Clark. Within 10 days of the broadcast, List was arrested at his workplace in Richmond on June 1, 1989. He was 63 years old. He was extradited to New Jersey and stood trial in 1990. The defense argued that List had suffered from severe depression and post-traumatic stress from his wartime service, and that his mental state at the time of the killings had been compromised in ways that should affect how the law assessed his culpability. Psychiatric experts testified on both sides of the question. The prosecution's position was that whatever mental distress List had experienced, the meticulous nature of the planning, the letter, the arrangements to delay discovery, the careful preservation of the bodies in the ballroom, the systematic destruction of his photographs before he left, all of it pointed to a man who had understood exactly what he was doing and had worked deliberately to carry it out and evade its consequences. The jury agreed. On April 12, 1990, John List was convicted of 5 counts of first-degree murder. He was sentenced to 5 consecutive life terms, making him ineligible for parole for an amount of time that exceeded any normal human lifespan. He would not be leaving prison. He died on March 21, 2008, at the age of 82, at a hospital in Albany, New York, to which he had been transferred from the Sullivan Correctional Facility in Fallsburg. The cause of death was complications from pneumonia. He had spent 18 years in prison. He never expressed what anyone around him recognized as genuine remorse. Breeze Knoll, the Victorian mansion at 431 Hillside Avenue, burned to the ground in August 1972, 9 months after the murders, in a fire officially ruled as arson. No suspect was ever identified. The house where List killed his family, and then turned on all the lights and walked away, no longer exists in any physical form. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the quiet streets of Westfield, New Jersey, we travel south to Wilkes-Barre, Pennsylvania, and the morning of September 24, 1982, when a former prison guard dressed in military fatigues walked out of a house on Schoolhouse Lane carrying an AR-15 rifle. By the time it was over, 13 people were dead, 5 of them his own children, and it remained the deadliest single-day massacre in Pennsylvania history for decades. Case 10. George Emil Banks. George Emil Banks was a former Army veteran and prison guard from Wilkes-Barre, Pennsylvania. On the morning of September 25, 1982, he dressed in military fatigues, picked up an AR-15 semi-automatic rifle, and killed 13 people across 2 locations in the Wyoming Valley. 5 of the dead were his own biological children. The youngest was 1 year old. It remains the deadliest mass killing carried out by a single person in Pennsylvania's recorded history, and Banks spent the next 4 decades dying slowly in a prison cell, rather than on the execution gurney the jury prescribed for him, because the courts eventually concluded that his mind had deteriorated to the point where executing him would violate the Constitution. He died in prison in November 2025 at the age of 83, of kidney cancer, 43 years after the morning on Schoolhouse Lane. Banks was born in Wilkes-Barre in June 1942, the son of a black man and a white woman who were not married. He grew up biracial in a mid-century northeastern Pennsylvania city, where that meant occupying an uncomfortable space between communities that did not fully claim him. His attorneys would later lean heavily on that experience at trial, arguing that chronic racial exclusion had fundamentally damaged his psychology. Banks himself offered his own explanation after the killings. He said he had murdered his children to spare them the pain of growing up biracial in a racist society. That statement, made in the immediate aftermath of 13 deaths, became one of the most discussed and most disturbing elements of a case that had no shortage of disturbing elements. His adult life before 1982 had not been clean. In 1961, he robbed a tavern with accomplices and shot the unarmed owner. He was convicted and sentenced to 6 to 15 years in prison, a term extended when he escaped briefly in 1964. He was paroled in 1969 and had his remaining sentence commuted by the governor in 1974. After his release, he married, had 2 daughters, and divorced in 1976. From that point forward, he formed relationships exclusively with white women, several of them simultaneously, and the household he maintained in Wilkes-Barre by the early 1980s included multiple women and their children living under his roof. In 1980, despite his prior felony conviction, he was hired as a corrections officer at Camp Hill State Prison. That hiring was a procedural failure that no one addressed until it was far too late to matter. By the morning of September 25, 1982, Banks had been drinking heavily the night before and had taken prescription medication. He dressed in fatigues, loaded the AR-15, and started inside the house on Schoolhouse Lane. He killed 3 women, all mothers of his children. He killed children. 2 of the women who died were sisters. When he went outside, he shot 2 men he encountered on the street, killing 1. He then drove to a mobile home park in Jenkins Township where additional family members lived and continued firing. The total across both locations when it was over was 13 dead, 7 children, including 5 of his own, aged 1 to 6, their mothers, and bystanders who had simply been present. After the second location, Banks barricaded himself in a house in Wilkes-Barre. Police set up a perimeter and began negotiating. Officers broadcast a false radio report claiming his children were alive and needed blood transfusions, hoping the lie would bring him out. It worked. Banks surrendered after a 4-hour standoff and was taken into custody without further violence. He was charged with multiple counts of murder and transported to the Luzerne County Jail. The trial was moved to Allegheny County on a change of venue. Banks was disruptive throughout. He overruled his attorneys repeatedly, introduced evidence himself, and used portions of the proceedings to argue that the judge, the prosecutor, and the mayor of Wilkes-Barre were conspiring against him. His defense team argued insanity, presenting testimony about the psychological damage of his upbringing and the racial pressures he had lived under. The jury was not persuaded. On June 22, 1983, they found him guilty of 12 counts of first-degree murder and 1 count of third-degree murder. The next day, they recommended 12 death sentences. He was formally sentenced accordingly. The death sentences then proceeded to do almost nothing for the next 4 decades. Pennsylvania had not carried out an execution in years, and the Banks case moved through the appeals process at the pace these cases typically move, which is to say extremely slowly and with no guarantee of arrival at any particular destination. Execution dates were set and then interrupted. Legal challenges wound through state and federal courts. The case that eventually consumed the most time and generated the most significant legal rulings was not about his guilt, which was never seriously contested, but about his mental competence to be executed. Beginning in the early 2000s, psychiatric evaluations of Banks began producing a consistent finding: he was psychotic, delusional, and irrational. He had developed a fixed belief system that had displaced his capacity to understand his own situation in any rational way. He believed his death sentences had been vacated by God. He believed a former president had intervened in his case. He believed divine authority had superseded the authority of the Pennsylvania courts. Multiple independent psychiatric experts across multiple competency hearings reached the same conclusion: this man did not have a rational understanding of why he was facing execution, which meant that under the standard the United States Supreme Court had established in Ford v. Wainwright, executing him would constitute cruel and unusual punishment and violate the Eighth Amendment. Luzerne County Senior Judge Joseph Augello, who presided over one of the competency hearings, described Banks's mental state in terms that have stayed with people who followed the case. He called it a tossed salad of ideas and beliefs. He found Banks unfit for execution. That finding was reviewed by higher courts and affirmed. In 2011, the Pennsylvania Supreme Court formally removed the death penalty from Banks's case, ruling that his psychological deterioration was permanent and that he could never be executed consistent with constitutional requirements. His sentence became life imprisonment. The teenager who had been shot by Banks on the street outside the Schoolhouse Lane house on September 25, 1982, survived. He grew up and watched the legal proceedings unfold across the following decades. In 2012, when Banks had been in prison for 30 years and was showing no sign of dying in any foreseeable time frame, the survivor said publicly what many people in the Wyoming Valley were thinking: that the death penalty was functionally meaningless if a man who had shot 13 people, including 5 of his own young children, could simply live out his days in a prison medical facility until his body gave out on its own schedule. That was not an argument about whether Banks deserved to die. It was an argument about the gap between what a sentence is supposed to mean and what it often becomes in practice when the legal system operates across decades rather than years. Robert Gillespie, the district attorney who prosecuted Banks in 1983, gave interviews at the 10-year, 20-year, and 35-year marks after the killings. Each time, the details he recalled were precise: the image of the children, the scale of the blood loss inside the Schoolhouse Lane house, so severe that it had dripped through the floorboards into the basement, the Easter candy that had been spattered at the second location, in Jenkins Township, where the children had been involved in a holiday celebration before Banks arrived. Gillespie said he believed Banks deserved the death penalty, and that the failure to carry it out was an injustice. He said it plainly, and without apparent hesitation, across 4 decades of being asked about it. George Emil Banks died on November 2, 2025, at SCI Phoenix in Montgomery County. He was 83 years old. His cause of death was renal neoplasm, a kidney cancer that had progressed to the point where his body could no longer sustain itself. The Pennsylvania Department of Corrections confirmed the death. He had been continuously incarcerated since September 24, 1982, the day of the killings. That was 43 years, 1 month, and 8 days. The 5 children he killed would have been in their mid-40s at the time of his death had they survived. The shooting at Schoolhouse Lane and Jenkins Township remains the worst single-perpetrator mass killing in Pennsylvania history. No subsequent event in the state has exceeded its body count. The families of the victims, including the mothers of his children who survived and the siblings of the dead, spent those 43 years watching a legal process that produced a death sentence, then produced competency hearings, then produced a commutation to life, and then produced a natural death in a prison medical facility. Whether that constitutes justice is a question the case does not resolve. What it resolves is factual. 13 people died on a September morning in 1982, 5 of them children aged 1 to 6, and the man who killed them outlived the sentence a jury prescribed for him by more than 4 decades. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the Wyoming Valley of Pennsylvania, we move to a suburb just across the Mississippi River from St. Louis, where a former Marine and security guard for a prominent televangelist ministry strangled his wife and their 2 young sons in their beds one May morning in 2009. The threatening letters he had been sending to his own home for weeks were supposed to point investigators somewhere else entirely. Case 11. Christopher Coleman. In the spring of 2009, a family of 4 lived in a 2-story house in Columbia that fit that description precisely. On the morning of May 5, a family member who had been unable to reach Sherry Coleman by phone asked police to check on the household. What officers found inside changed the way the people of Columbia understood the quiet street they had lived on. Christopher Coleman was 31 years old in May 2009. He had grown up in a religious household and had served in the United States Marine Corps before transitioning into private security work. In the years leading up to 2009, he had secured a position that carried a degree of local prestige. He worked as a personal security guard for Joyce Meyer, the televangelist and Christian author, whose ministry, based in Fenton, Missouri, operated internationally and generated significant revenue. The position required Coleman to maintain a public image consistent with the values the ministry projected. He traveled with Meyer, managed security logistics for her appearances, and was visible in the professional environment of a prominent Christian organization. He was, in the world he had built around himself, a man whose life appeared to be grounded in faith and family. His wife, Sherry Coleman, was 31. They had 2 sons, Garrett, who was 11, and Gavin, who was 9. By the accounts of people who knew them, Sherry was warm and devoted, a woman whose faith was central to her life, and who raised her sons with clear values and evident love. The family attended church together. They were part of the community fabric of Columbia, in the way that families who stay close to their roots and their faith tend to be. Friends of Sherry's who were interviewed in the period following the murders described a marriage that had its stresses, but that appeared, from the outside, to be intact. What was not visible from the outside was that Coleman had been conducting an extramarital affair for an extended period. The woman he had been seeing was a high school acquaintance he had reconnected with, and the relationship had been ongoing for years without Sherry's knowledge. By 2009, Coleman wanted to formalize that future and had come to view his wife and children as an obstacle to what he intended his life to become. His position at Joyce Meyer Ministries complicated the situation further. The ministry's culture and values were explicitly incompatible with divorce and extramarital relationships, and Coleman was aware that leaving his marriage would in all likelihood cost him his job and the professional standing that came with it. His solution to this set of pressures was to construct a scenario in which the danger to his family appeared to come from somewhere else. Beginning in early 2009, threatening letters began arriving at the Coleman household. The letters were crude in their content, threatening violence against Sherry and the boys, invoking biblical language in dark and distorted ways, and suggesting that Coleman's work for the ministry had made enemies who intended to harm those he loved. Coleman reported the letters to the ministry and, eventually, to police. He positioned himself as a family man under threat, someone whose dedication to his professional and spiritual life had placed his household in danger. The letters generated concern among people around him and provided a framework for understanding the household as a target from the outside, rather than a place where the threat originated within. Investigators who examined the letters in the months before the murders and then in the investigation that followed identified stylistic and linguistic patterns that pointed toward a single author. Analysis of the paper, the phrasing, and the content of the letters, combined with examination of computer records from the Coleman household, eventually led investigators to conclude that Coleman had written them himself. The threatening correspondence he had been generating was designed to establish, in the minds of anyone who might later be looking back at the family's final months, a credible alternative explanation for what was coming. On the morning of May 5, 2009, Christopher Coleman left the house early, reportedly to exercise at a nearby gym. A family member who had been expecting to hear from Sherry that morning could not reach her and grew alarmed. When police responded to the welfare check and entered the house, they found Sherry Coleman strangled in her bed. In the boys' rooms, Garrett and Gavin had also been strangled, each in their own bed. The manner of the deaths, strangulation, left no evidence of a weapon and no sign of forced entry or struggle that would be consistent with an intruder having come in from outside. On the walls of the house, words had been spray-painted in large letters, messages threatening Coleman's family using the same kind of language that had appeared in the threatening letters. The staging was extensive and had been carried out with some deliberateness. Coleman was brought in for questioning. He maintained through the initial stages of the investigation that he had left the house that morning without any awareness of what had happened, and that he had been away from the property when his family was killed. He expressed grief. He pointed to the letters and the painted messages as evidence that the threat he had been reporting for months had been carried out by someone targeting him through his family. The investigation, however, moved quickly in the direction the physical evidence pointed. There was no sign of forced entry. The manner of death was consistent with someone who had access to the household and direct physical contact with each victim over a sustained period. The threatening letters were being examined forensically. Records from Coleman's phone and computer were being analyzed. Within weeks, investigators had assembled a picture that pointed firmly at Coleman. The affair, which had been kept entirely from Sherry, was documented in communications that established both its existence and the pressure Coleman had felt to resolve his domestic situation. The analysis of the threatening letters reinforced the conclusion that they had come from inside the household. A neighbor's security camera had captured Coleman's vehicle at a time that conflicted with elements of his account. The case built steadily and in one direction. Coleman was arrested and charged with 3 counts of first-degree murder. His trial began in May 2011 in Monroe County. The prosecution's case was organized around 4 central elements: the affair and the motive it established, the threatening letters and their authorship, the physical evidence from the crime scene, and the absence of any credible evidence pointing to an outside perpetrator. They called more than 40 witnesses across the trial, including the woman Coleman had been involved with, who testified about the relationship and about conversations in which Coleman had discussed the constraints his marriage placed on his plans for the future. The defense argued that the case was built on circumstantial evidence and that the prosecution had not established beyond reasonable doubt that Coleman was responsible for the deaths. They challenged the letter analysis, contested elements of the timeline, and argued that investigators had focused on Coleman to the exclusion of other possibilities. The jury did not find the defense account persuasive. After deliberating for less than 2 hours, they returned guilty verdicts on all 3 counts of first-degree murder. The sentencing proceedings came the following day. The jury, having found Coleman guilty, then considered whether he should be eligible for the death penalty. Illinois had been moving toward abolishing capital punishment for some time, with Governor Pat Quinn having indicated he would commute any death sentences imposed before the abolition took formal effect on July 1, 2011. The jury nonetheless found Coleman eligible for the death penalty, based on the existence of aggravating factors. When it came to the formal sentencing, Coleman waived his right to have the jury decide the sentence and placed that determination in the hands of Judge Milton Wharton. The arguments to the judge reflected the complicated position capital punishment occupied in Illinois at that moment. The lead prosecutor, Chris Reitz, told Judge Wharton that the jury's eligibility finding deserved to be honored and pressed for the maximum sentence. He asked aloud what kind of case, if not this one, warranted the ultimate penalty. Coleman's defense attorney, John O'Gara, made a different argument, noting that a life sentence was, in practical terms, already a form of death sentence, a permanent confinement from which Coleman would never emerge, a 6 by 11-foot space shared with another person for 23 hours a day, every day, until death. He asked for mercy. Judge Wharton sentenced Coleman to 3 concurrent life terms without the possibility of parole, citing the horrible nature of the crimes and the setting in which they had occurred, the family's own beds, spaces that should have been the furthest thing from what they became on the morning of May 5, 2009. Coleman's conviction was upheld on appeal by the Illinois Appellate Court, which reviewed the evidentiary and procedural arguments his attorneys had raised and rejected them. He remains incarcerated at Graham Correctional Center in Hillsborough, Illinois, where he has been held since shortly after the sentencing in 2011. Cherry Coleman was 31 years old. Garrett was 11. Gavin was 9. They were found in their beds in a house in a quiet city just south of St. Louis, where families moved to raise children at some remove from the pressures of the larger world. The threatening letters Coleman had mailed to his own family across the months before the murders are part of the evidentiary record of the case, preserved in the files of the Monroe County court system. The spray-painted words on the walls of the house were documented by crime scene photographers before the house was cleaned. The gym Coleman said he had gone to exercise that morning is still there. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the Illinois side of the Mississippi, we travel to Texas and a New Year's Day in 2008, when 2 teenage sisters were found shot to death in a taxicab outside a hotel in the Dallas suburb of Irving. One of them had called 911 from the cab and named her father as the man who had shot her. That father disappeared for 12 years. When he was finally found, he was 30 miles from where his daughters had died. Case 12, Yasser Abdel Said. On the evening of December 31, 2007, and into the first hours of January 1, 2008, a taxi driver named Yasser Abdel Said told his 2 teenage daughters that he was taking them out for New Year's Eve dinner. The girls got into his cab. By the time a hotel employee noticed the vehicle parked outside near a lane designated for taxis, Sarah Said, who was 17, was on the phone with a 911 dispatcher, telling the operator that her father had shot her and that she was dying. She was. Her 18-year-old sister Amina was already gone. Yasser Abdel Said was born in Egypt on January 27, 1957, and came to the United States as a young man, eventually becoming a naturalized citizen. He settled in the Dallas area and built a life there, working as a taxi driver and raising a family. He met Patricia Owens when she was 14 years old and he was 29. He married her when she was 15, with the permission of her parents, after a courtship of approximately 3 weeks. The age gap, the speed of the marriage, and the subsequent history of the relationship were all elements that Patricia would describe in detail when she eventually testified publicly about what her life with Yasser Said had been. He was controlling from the beginning, she said, and the control intensified over time. He determined where the family went, who they saw, what his children were permitted to do, and what the consequences would be for behavior he judged unacceptable. The couple had 3 children together, a son named Islam and daughters Amina and Sarah. The family was known in the communities where they lived across the Dallas area. Said maintained a strict and traditional set of expectations for his daughters that went well beyond what the people around them considered ordinary parental oversight. The girls attended Louisville High School and were, by the accounts of teachers and friends who knew them, bright and sociable young women who wanted the kind of life that teenagers around them were living. They had American friends, they had boyfriends, young men from outside their cultural and religious background. They participated in school activities. These things, in Said's framework, were not acceptable. He had expectations about who his daughters would marry and how they would conduct themselves, and the lives they were quietly building at school were in direct conflict with those expectations. In the years before the killings, both girls had made statements to people they trusted that conveyed the seriousness of what they feared. Amina Said sent an email to a teacher at Louisville High School in December 2007, less than a month before her death, in which she described the situation plainly. She wrote that her father had made their lives a nightmare. She wrote that he would, without any drama or doubt, kill them. She and Sarah had also previously approached police with a sexual assault complaint against their father, a report that did not result in charges. The pattern of fear the two girls described was consistent and documented, and it was known to at least some adults in positions where something might have been done. Nothing sufficient was done. In late December 2007, Patricia Owens took the girls and left the family home in Louisville, traveling to Oklahoma with Amina, Sarah, and their respective boyfriends. Said's response to their departure was intense. He contacted Patricia repeatedly and eventually persuaded her to return, telling her that things would be different. The family came back to Texas. Whatever Patricia hoped would happen when they returned, what actually happened was that Said's anger had not been resolved by the weeks of separation. It had settled into something colder and more fixed. On the evening of December 31, Said told the girls he was taking them to dinner. They got into his taxi. He drove them to a location in Irving, near a hotel on a commercial corridor. What happened inside the cab in those final minutes has been established through the physical evidence, the forensic record, and the 911 call that Sarah managed to make as she was dying. Said shot Amina twice, both bullets entering through the heart. He shot Sarah 9 times. Before she lost consciousness, Sarah Said called 911 on her cell phone and told the dispatcher that her father had shot her and that she was dying. She named him. The recording of that call was played at his trial 14 years later, and people who heard it in the courtroom described the experience as one that did not easily leave them. Said then parked the taxi outside the hotel and left the area. A hotel employee named Nathan Watson noticed the cab sitting in the taxi lane with 2 young women inside who were not moving. He approached the vehicle and saw that something was badly wrong. Emergency services were called. By the time medical personnel arrived, Amina was dead. Sarah died shortly afterward. Said was gone. He had vanished into the Dallas area and would remain missing for more than 12 years. A capital murder warrant was issued for his arrest within days. Irving police and the FBI coordinated on the investigation. Said was placed on the FBI's 10 most wanted fugitives list in 2014, where he remained for 6 years. Appeals to the public through various law enforcement channels, including the television program The Hunt with John Walsh, kept his name and photograph in periodic circulation, but no confirmed sighting materialized and no arrest followed. Years passed. Amina and Sarah's birthdays passed. New Year's days came and went. The man who had killed them remained somewhere in the country, living under whatever arrangement he had made with the people helping him stay hidden. Those people eventually became part of the legal record as well. Said's son Islam, who had been a young adult at the time of the killings, was among those who helped his father evade law enforcement over the years that followed. Said's brother, Yassin Abdul Fattah Said, was also involved. The 2 men kept Said housed and supported, moving him between locations in the Dallas-Fort Worth area as needed. Said was eventually staying in an apartment in a complex in Bedford, Texas, then relocated to Justin, a small city about 35 miles northwest of Irving, where he was living with family members when a maintenance worker at the apartment complex recognized him in 2017. That recognition did not lead to an immediate arrest, and Said was moved again. He ended up in a home in Justin, where he was finally located by the FBI on August 26, 2020. The arrest was made without significant incident. Said was 63 years old. He had been a fugitive for 12.5 years. He was taken into custody in the Dallas-Fort Worth area, approximately 35 miles from the hotel parking lot, where he had left his daughters to die on the first morning of 2008. Islam Said pleaded guilty to charges of harboring a fugitive and conspiring to obstruct justice, and was sentenced to 10 years in federal prison. Yassin Said was convicted at trial of conspiracy and harboring a fugitive, and sentenced to 12 years in federal prison. Yasser Said's trial began in Dallas in August 2022, before Judge Chika Anyam. He testified in his own defense, speaking through an Arabic translator. His account was that he had been driving his daughters to dinner when he became aware that someone was following the taxi, and that he feared for his safety. He said he left the girls in the cab and fled into a nearby wooded area, and that when he returned, the cab was gone. He said he did not know what had happened to them. He said he did not kill his daughters. He sat in the courtroom and offered this account, while Sarah Said's voice played from a recording made on the last night of her life, a voice telling a 911 dispatcher that her father had shot her. Patricia Owens testified about the marriage, about the control Said had exercised over the family across decades, and about the fear his daughters had lived with. Friends and teachers who had known Amina and Sarah testified about the girls themselves and about the email Amina had sent in December 2007. Expert witnesses addressed the nature of what prosecutors characterized as honor-based violence, the pattern of control and punishment that had defined the family's experience. The prosecution's lead attorney, Lauren Black, told the jury that Said had been obsessed with possession and control, and that his daughter's decision to live on their own terms, to have American friends and boyfriends and plans that he had not approved, had been something he could not tolerate. The jury deliberated for approximately 3 hours before returning a unanimous guilty verdict on the charge of capital murder. Said showed no visible reaction as the verdict was read. Prosecutors had decided before trial not to pursue the death penalty, which meant that the capital murder conviction carried an automatic sentence of life in prison without the possibility of parole. Judge Anyam imposed that sentence. Before he was led out of the courtroom, Said heard Patricia Owens address him directly. She called him the devil. She described what he had taken from her and from Amina and Sarah, the graduations they would never have, the careers they had talked about, the lives that had existed in their plans and their conversations, and in the emails they had sent to teachers they trusted when they had no other way to say what they were afraid of. She said he had brainwashed their son. She said he had taken her family all in one night. Yezer Said is currently incarcerated at the McConnell Unit of the Texas Department of Criminal Justice in B County, Texas. He is 68 years old. Islam Said is serving his federal sentence. The girl's mother continues to live with what was taken from her on the first day of 2008. Amina Said was 18. Sarah Said was 17. Sarah's 911 call is preserved in the evidentiary record of the case, available to anyone who needs to understand what the last minutes of her life sounded like and what she did with them. If you enjoyed this breakdown, make sure to subscribe. Thanks for watching, and I'll see you in the next one.